Parviz Jarabi, attorney at law, have been practicing for over 20 years. Our office is located by San Francisco Airport, specializing in employment law. Today's topic, unemployment benefit eligibility in California, part 2. Unemployment insurance benefits provide temporary financial assistance to workers who, through no fault of their own, have become unemployed. In California, you may qualify to receive unemployment benefit if you have been out of work through no fault of your own. The agency in California that handles the state unemployment insurance program is called the Employment Development Department, EDD. EDD manages and oversees the program and is responsible for determining eligibility and providing payments to those who apply. You are also eligible to receive unemployment benefits in California if you're fired from your job because you lack the skills to perform the job or simply were not a good fit. However, if your employer can prove that you were fired because of misconduct on your part, you will not be eligible for unemployment benefits. In California, misconduct makes you ineligible for unemployment benefits only if all four of these statements are true. You owed a material duty to the employer. This means a duty that is part of the job. This can be, for example, showing up for work and performing your job duties. You substantially breached that duty. In other words, you did not perform the duty. A minor or one-time or isolated instance isn't enough to disqualify you from receiving benefits. Your breach of duty showed wanton or willful disregard for that duty. In other words, you were not just careless or thoughtless, but instead intentionally violated duty or showed a reckless disregard for the consequences of your breach of the duty. Inefficiency, inability to perform the job, or good faith errors in judgment don't meet this standard and won't render you ineligible for unemployment benefits in California. Your breach of duty must tend to harm the employer's business interest. If you quit your job, you won't be eligible for unemployment benefits unless you can prove you had a good reason for quitting, meaning that a reasonable person who truly wanted a job would have left under the same circumstances as you did. For example, if you had good cause related to your job, such as illegal discrimination, harassment, unsafe working conditions, or fraud by your employer, you will be eligible for unemployment benefits. In this situation, you must have taken reasonable steps to resolve the situation before quitting, which means you must have discussed the problem with your employer and allowed a reasonable amount of time for the employer to fix the situation before you left the job. If you left your job for compelling family or health reasons, because you're facing domestic violence, need to relocate to follow your spouse, or need to care for a seriously ill family member, for example, you likely will be found to have a good cause to quit, and you will be eligible for unemployment benefits. If you were a California employee and currently experiencing unemployment, you might be eligible for unemployment benefits. California eligibility requirements can be confusing. Remember, your rights as an employee are protected by law. So stay informed, know your rights, and advocate for fair treatment in the workplace. If you have any questions on this topic, please contact my office for free consultation. Please be sure to like and subscribe and turn on your notification.